welcome to the United States Court of Appeals for the Fourth Circuit. We have two cases on for argument this morning. Before I begin, I want to recognize and thank our district court colleague, Judge Patricia Giles from the Eastern District of Virginia, who has taken time away from her busy docket and other day job to join us here this morning, and we're grateful to you for being here. All right, first case up is 24-2051 Rockwell Mining LLC versus Pocahontas Land LLC. Mr. Lane.
May it please the court, I'm Tom Lane. I represent Pocahontas Land, and with me is my partner, Gabe Wool. Pocahontas Land seeks a forfeiture in this case. We recognize that it is normally a difficult remedy. However, in this case, we have a tenant on the property that has violated the terms of the lease, has actually not played by the rules, and we submit that this is a proper case for forfeiture. Both sides in this case agree that forfeiture can be based on contract and in equity. The district court in this case limited its ruling to the Bethlehem Steel case, which held that forfeiture is not available under contract unless the lease in question has certain technical requirements. It must have a forfeiture clause that provides for forfeiture, and the terms for forfeiture must be expressed in the lease. The court did not recognize a core limitation in the Bethlehem Steel case. A condition to the holding in Bethlehem Steel was that forfeiture is not available as long as there is an adequate remedy at law. In Bethlehem Steel, the owner of the property, the landlord, recovered over $10 million in monetary damages and terminated the coal lease that was an issue in that case. And that condition, that there was an adequate remedy, led to the decision that forfeiture would not apply. In this case,
a question about that. So in theory, assuming you could prove damages, couldn't you recover money damages for a breach of this lease?
Your Honor, in this case, the damage, the harm that was caused is the Pocahontas. This is not a case about money damages. It's a case about the landlord, the owner of the property, having some control over who the tenant is. And that's an extremely important issue in this case, where you have an extraction process that's ongoing on the property.
Well, I understand that, but assuming that that lack of control somehow led to your client suffering monetary damages, you could recover for that, right?
Your Honor, the actual monetary damages in this case probably would not be realized.
Because there are no damages that you can prove.
There are no monetary damages we can calculate.
And you're trying to extract a remedy that is not a match with respect to the breach that you're alleging, right?
We're not seeking monetary damages,
I know,
Your Honor.
because you have no damages.
We haven't yet. In this case, we not only have an extraction going on, the tenant on this property has a mammoth surface mining operation on the property, and associated with that surface mine.
Well, I'm sorry to interrupt you, Mr. Lane, but there's a lot about this contract that's very strange, including the fact that for whatever reason, there's not an escalator clause that would increase the amount of royalties that your client would be entitled to. And I get that. That's bothersome and troublesome. But the reality is your client is still being paid the amounts that it is due under this lease, right? Yes?
They are paying, yes, Your Honor.
Okay. So what are the damages as a result of a reassignment of the lease?
Your Honor, we assert that under West Virginia law, we don't have to prove damages. They are not necessary.
Why is that?
We have a whole line of cases in West Virginia that say that forfeiture is available in equity. And the reasons for it are, number one, and this case fits exactly the Warner v. Hott case that we have cited. And Warner v. Hott, the court said, where a lessee repeatedly violates the terms of a lease, a lessor is entitled to forfeiture. And that's exactly what happened in this case. There were 7 separate violations of the lease, 5 deeds of trust and 2 changes in ownership.
What were the nature of the violations in the case you just cited?
In the Warner v. Hott case, the violations the court talked about were failing to pay rent when it came due. And the court said if the lessor has to assert a default, possibly go to court repeatedly to try to get paid the rent that's due under the lease, the lessor is then entitled to forfeit the lease. The other line of cases, probably the most frequent injury that occurs are in oil and gas mineral cases where the finding is there's a failure to develop the property. And the court, in almost every one of these cases, holds that it's almost impossible to know in money damages how much might have been earned had they performed the core obligation they were supposed to perform.
But
And
that's not the issue here, right? It's
Pardon?
not that they're not performing under the contract.
That is correct. I'm just saying, in the cases that allow a forfeiture, the facts are different in all of them. I'm just saying that in every one of these cases, monetary damages could not be ascertained.
The problem here is with the forfeiture clause at issue, because it is problematic. It's one of the general clauses.
Correct.
We do have provisions in the lease that do allow for forfeiture, correct?
Correct.
For those violations. These violations don't allow for it. And that's just per the contract. That's what was negotiated.
So our second argument obviously deals with the fairness of the contract and whether it was unconscionable. In this case, the one protection that the lessor, the owner, has in this case is control of who its tenant is.
Well, you know, you had a bankruptcy that intervened in here in the case. Did you raise the argument that Article 16 expressly includes the transfers that occur by operation of law, such as bankruptcy, before the district court? Did you raise that issue?
Your Honor, that issue was before the district court. There was a change in ownership that occurred in bankruptcy, and we think the district court finding on that was correct, that in bankruptcy, the prohibition against assignment does not apply, and the bankruptcy court has the right to assign the asset.
So didn't that gum up your argument?
It came up to the argument. Rockwell argues in this case that under the terms of this lease, if there's one change in ownership, it's one and done, it's all over with, and that simply is not the case. That is not what the provision provides.
Doesn't it, I'm sorry.
Go ahead. No.
Doesn't it identify a control group, and so by definition, it's limited to that set of persons and doesn't have a life beyond that provision?
It does say, in the 2015 amendment, it provides that if there's a change in control of 51% beyond the owners who own it at that time,
Right.
it's prohibited. Well, those literal words still apply. And the bankruptcy court could assign the lease, but it can't change the terms. Those terms still apply. You still can't assign this lease or have a change in ownership to those that didn't own it in 2015 at that time. So the literal prohibition still applies. And it was violated twice.
Well, kind of in that regard, have you identified any court opinion holding that a financing agreement with a savings clause cannot reach the anti-assignment or assignment consent provision?
Neither side cites a case squarely addressing the savings clause that was in these leases. The literal terms of the savings clause in the deed of trust simply says the lenders will have no liability if there's a violation of the consent requirement. The literal terms of the savings clause do not negate the fact that this lease was assigned in the deed of trust to a trustee, and the banks had authority in the event of default to sell the lease with no control by the owner of the property, none. And so the savings clauses simply did not negate the fact that there was a valid deed of trust that imposed a lien on the property, and the banks could have sold this lease with no consent provision from the lessor. So,
I'm looking down the road just a second, not just to this case, but if we were to affirm the district court's holding as to the savings clause, would it impact West Virginia energy transactions, including leaseholds that include savings clauses?
Your Honor, I suppose...
I'm talking about opening the floodgate type thing.
I can say from experience, these issues come up frequently. Lessees need to borrow money periodically, and they are considered in every instance, and I can tell you, deeds of trust do get authorized. But in a case like this, there's no obligation by the lessor, the owner of the property, to make a concession. Absolutely none. If they had come and asked for a concession, it would likely have opened up some negotiation. We missed an opportunity because in no instance they imposed 5 deeds of trust, and not once did they come to the owner and say, we need your consent, will you sit down with us and make a concession?
Why didn't you do more negotiation back in 2015 when you did the amendment?
I'm not sure I can answer that question, Your Honor. The occasion in that instance was a sublease of a minor portion of the property. And in order to sublease it, they needed the consent of the owner. And so at that time, they were able to get an amendment to the lease that added to the prohibitions against assignment and added the prohibition there couldn't be a change in ownership without consent. So they did get some concession in 2015, and that's what it was.
Well, if we were to find that the court didn't err in its analysis of unconscionability and termination, would we have to reach the related contract, breach of contract issues?
I'm sorry, I didn't get the last.
I'm sorry, I'm talking too soft today. If we were to find that the district court did not err in its analysis of the unconscionability and termination, would it be necessary? Would we have to then consider the related breach of contract issues, or we don't have to consider them?
So if there were a finding of unconscionability, the remedy would be reformation of the contract, and we would get to revisit the terms and at least try to make them fair.
But if we held the other way, do we have to reach the breach of contract issues?
I believe so. I believe that the remedy of unconscionability is totally independent of the breaches of the lease that took place in this case. And while the contract, we believe, is fundamentally unfair, the forfeiture remedy is totally independent, and it rests upon the repeated breaches of the contract.
In what time frame do we measure that? At the time the contract was entered into in 1937, or in today's world?
Your Honor, 2 aspects of unconscionability: procedural and substantive. Procedural, of necessity, has to be measured when the contract was entered in 1937. Substantive, I think the West Virginia law is not entirely clear on whether it's evaluated in 1937 or whether you can test it today. And frankly, we have dicta Rockwell has cited two cases that suggest you have to analyze it in 1937 when it was entered into. It also cites the Iafola case. And in the Iafola case, the court held that a rent paid today might become unfair in the future.
But the problem with that is then you could be shifting. At one moment, it could be conscionable, and then the next moment, unconscionable. So that's the problem if the timing shifts, right?
I have to agree with that. You're correct. And my answer is, in this case, we believe the contract was substantively unconscionable in 1937, not just due to the flat rate rent. It was the combination of a flat rate rent, a perpetual renewal, and no reopener. So we're 90 years after the fact, and there's never been a chance to adjust the terms of the lease. The experts in this case could...
But there was a time in 2015, because didn't you look at it then?
I can't speak to the negotiations that took place in 2015. They did exact a concession, but you're correct, Your Honor. When they sat down and negotiate, they did not increase the royalty rate, and it was probably just as bad then as it is today.
Well, you can't tell from the record, but it seems to me that what happened in 1937 was a common practice with railroads, coal folks, the whole deal. You can't tell how much incest there is in all these parties. How many were that the smaller party who agreed to do something in connection with that? What was the interconnection? Or were they just strangers, or were they incestuous?
Well, Your Honor, we took a deep dive in the history of this case, and we hired experts, we did research on what the circumstances were in 1937. And the clear facts are that Andrew Mellon owned a significant interest in the lessor, he owned the lessee, and more than that, he owned the railroad. And he had a vertical integration where he had everything from ownership of the coal in the ground to the mining company to the shipping company. And the facts indicate that one of the most important considerations wasn't the royalty income, the income from the mining, it was the profits they were going to generate from shipping the coal. And in our estimation, when you start and look at a contract that is substantively unconscionable, and you have to ask yourself, what happened? How did these parties reach this agreement? And the simple answer is Andrew Mellon interests were on both sides. They were on the lessor side, the lessee side. They not only owned a significant interest, but there was common management. So you had management on both sides of the issue.
Does that in and of itself make this an unconscionable contract?
All it does is show that at the formation of the contract, this contract was not an arm's length negotiation between parties having different interests. And the only issue that we raise on this appeal is that in this case, we don't have to prove direct coercion. All we have to prove is that there was some slight procedural irregularity. And in this case, the common ownership, the dominance of the Andrew Mellon interest clearly indicate that this was not an arm's length negotiation. And the error that we suggest was in making a decision here on summary judgment. This did not go to the trier of the fact, and we think there is an issue of fact.
We're not dealing with a man's decision. We're dealing with sophisticated companies. And so you'd have to overcome that sophistication, would you?
We agree. The Andrew Mellon interests were sophisticated. There is no question. They even had congressional hearings on this general matter at the time.
Yeah.
So yes, we agree, Your Honor, they were sophisticated, but the common overlapping ownership and management clearly indicates this was not an arm's length negotiation. And it resulted in a contract that is fundamentally unfair, and as time goes on, it becomes increasingly unfair.
Well, as to your procedural and substantive argument, I mean, obviously there's a sliding scale in that regard. where is the procedural defect in 1937 on that scale? It seemed to me that it was further down the road than you want it to be.
All we can do is, we have done extensive research to uncover as many facts as we could, and what we did find is there was significant influence by one person on both sides of this equation.
Mr. Lane, you mentioned that Andrew Mellon was primarily interested in garnering the profits from the transportation of the coal. Is that what you said?
That's what was revealed in congressional hearings.
But that's not necessarily inconsistent with an opportunity to negotiate the royalty rates related to the lease. Those are two separate profit streams.
Your Honor, one of the things that the courts look to in these unconscionability cases is where you have a vertical integration and you have self-dealing among all the different companies. And that's all we're showing here is these companies were all interrelated. They were not disparate entities. You had one.
Yeah, but you've got to show that Loop Creek didn't have a meaningful ability to negotiate a reasonable royalty stream. And if the argument is that one party was primarily interested in a different income stream, I don't see how that connects to the inability of the other party to say, in exchange for that income stream, I want either a higher royalty rate or an escalator clause or some ability to terminate the lease depending on market forces.
Those would have been normal terms. I mean, the experts in this case have all indicated there aren't any leases like this out there anymore. I've been involved in this lease since 1987, and it is an outlier. And the reason is your common terms would not have a perpetual royalty, or they would at least have some reopener provision in it. And it's the combination. I mean, we can't argue that 10 cents a ton was not a traditional royalty in 1937, but combined with perpetual renewal and no reopener clause makes it fundamentally unfair, and you just don't see leases like that. This is an outlier.
All right. Thank you, Mr. Lane.
Thank you.
Mr. Glasser?
Thank you, Your Honor. Let me just take a second to get organized here. Okay. May it please the court, I'm really happy to be here today in what is essentially the West Virginia courtroom. I have 3 West Virginia judges who I knew and worked for, one of them behind me, so that's fun, and been colleagues with Tom for 30 years in the law, and he's a good friend of mine, and so it's nice to be up here with him too, talk about this case. Let me just go through some of the questions the court asked and answer them from our perspective. So the first question that was asked was about the Warner v. Hott case. And the Warner v. Hott case was a failure to pay the rent case, which is obviously the core, it's the core thing in a lease. I'm going to give you the property and you're going to pay me money for it. And in Warner v. Hott, they repeatedly failed to pay the rent, but did in fact ultimately cure, and still forfeiture was denied in the Warner v. Hott case. That was one of the first questions that the court asked. Let me go to the second. Hold on. Sorry, I got my notes here. Second, the court asked about abandonment cases. And to me, the line of abandonment cases is consistent with the idea that to get equitable forfeiture, you have to have something that can't be cured by money damages, which is something you asked about, Judge Diaz. And that's because abandonment of the lease, never developing an oil and gas lease, goes to the core of the bargain. I gave you an oil and gas lease, you promised to put some oil wells on it, you never put any oil wells on it. That core abandonment never exploits the mineral, which is the essence of a mineral lease contract. So that is a normal forfeiture case when you just totally abandon. And as you pointed out, Judge Giles, there's no abandonment here. We have been working this lease, paying the royalties, mining the coal. Now, my colleague Tom Lane, before he sat down, he talked about this conjunction idea, that the conjunction of two legal things, a conscionable lease that was normal he just told the court that the royalty rate was totally normal in 1937, and this renewal clause, that somehow the conjunction of two legal things could make a forfeiture, could make an unconscionable lease. And that doesn't make any sense to me from a legal perspective. If the lease is conscionable at the time it was made, procedurally and substantively, and as must be conceded, West Virginia law allows renewal of mineral leases so long as the mineral's being exploited, which is totally common and has been approved by court after court. How can two legal things cause a rescission of the lease?
Those are two separate principles, though, right? You've got a lease here that has a fixed royalty rate as of 1930, what, 30?
Yes, sir.
37, and a perpetual provision. It's not really in perpetuity, I guess, until the minerals no longer exist. It's those two combinations that we have to consider whether or not those two, that combination of things makes the lease substantively, or makes the lease unconscionable. So it just seems like a terrible deal.
It's definitely turned out not to be a great deal because it lasted so long for them. I'm sure it was a great deal in 1937. The evidence in the record is they paid $3 million for the property. We know they've been getting at least $100,000 a year, even if there was no mining for 88 years. So they've gotten back $8.8 million.
But isn't there evidence in the record that they're paying more for the maintenance and expenses of upkeep of the property than, and of course, that's not determinative, because I guess bad deals, that's the benefit of the bargain sometimes, but it just seems odd that, you wouldn't have some basis to try to level the playing field, and maybe that's not the test.
So courts have never put themselves in the position of being roving commissions about changing contract terms because somebody makes a bad deal. And that's why I think courts adhere, and West Virginia adheres. So West Virginia says substantive unconscionability is the time of making of the contract. And the cases I would cite for that are the Lang case, which was a 2002 case, and the Troy Mineral case, which is a 1986 case, both of which post-date the case my colleague cited, which was Iafola. And they adopt Restatement of Contracts Section 208, which clearly says conscionability is at the time of the making of the contract. And frankly, the UCC, the Uniform Commercial Code in West Virginia, and the actual site is in our brief, says textually in the statute, you judge conscionability at the time of making the statute. And the West Virginia Consumer Code, textually in the statute, says the exact same thing. So what they're up here arguing for is actually a very special carve-out for, I guess, mineral leases, because if it's a contract for the sale of goods, there's a statute that says you judge it at the time of making only. If it's a consumer contract, no matter how adhesive or terrible, there's a statute in West Virginia that says you judge it at the time of making only. And there are two cases, Lang and Troy Mineral, that adopt the Restatement Second of Contract Section 208, and the restatement in those cases say you judge substantive unconscionability only at the time of making. So I think even though there may be a bad deal for them ultimately because of how long it has lasted, although I'm sure they were deeply in the money in 1937, and they were more worried about prices going down than up because it was a depression, and maybe that's why they fixed the royalty rate. Certainly over time, that royalty is low now, no question about it, but that's why the law is you judge it at the time the parties bargained. So that's my position on that one. Now, on the renewal, there are two West Virginia cases. Iafola versus Douglas, a 1978 case, and Pechonik versus Baltimore, Ohio, a case around the same vintage in the 80s, but cites cases back to the 19th century. And all of them say renewal is normal. And if the court goes out and searches, just as a Westlaw search on the paying quantities, you'll find that most oil and gas leases, when you drill it, so long as it's being produced in paying quantities, that lease is renewed and maintained and stays. So that's super common. And if you do a Westlaw search for the concept of mineable and merchantable coal, you will find that most coal leases are renewable so long as mineable and merchantable coal is being mined and exploited. These are super common provisions in mineral leases, and the idea, it
Will any
makes
of those
sense.
cases affirm a lease that also has a fixed rate that's can't ever be negotiated?
There is not a conjunction of cases that affirmed lease renewal as is normal for leases and a 10-cent royalty, nor is there one going the other way. This exact circumstance has not been before a court, but I think you got to fall back on, you got to judge it at the time the contract is made, because that's the law. And both of the things they're citing, if it's a conscionable lease at the time it's made, procedurally and substantively, then it's legal. And because normal renewal during paying quantities or mineable merchantable coal is well-established law in all mineral states, but definitely in West Virginia, two legal things can't destroy your lease, or ought not destroy your lease, is I guess how I'd put it.
Your colleague on the other side makes an argument that the district court erred by not considering at all the second part of that equation with respect to unconscionability, because it found no procedural unconscionability. And they looked to the fact that Andrew Mellon seemed to be calling all the shots back then, which is probably true. I don't know. And they point to this integration, the overlapping interests, and that should have been enough to get them over the bar with respect to procedural unconscionability. What's your response to that?
So if you delve into the actual expert reports, I think you'll find there were 5 Millen children, each with 20% of the Millen interest, and there's no discussion in the expert reports about whether the 5 got along. The court, in his opinion, didn't get into that because the total Millen interest on the lessor side was 40% of the voting stock. And so the court said, fine, the Mellon family interest, which was actually 5 children, we don't know if they got along with each other or not, was 40% of the voting stock over there. That's not enough for control.
In total, among all 5?
Yes, in total.
Okay.
The 5 in total had 40% of the parent, ultimate parent, like 3 levels up of the lessor. But when you delve down into this, there is absolutely no record evidence of common management. If you look at the lease itself, which is JA 97 and thereafter, you will see it's signed by 2 separate parties. There was a Loops president and there was a Coppers president, 2 separate people. There is no record evidence. My colleague said common management. There's no record evidence in this case of common management whatsoever. There is simply a lease that isn't even a parent subsidiary relationship. The lessor didn't own.
How do you respond to their argument that there was no indication of there being separate representation of counsel?
Yeah, so we go into that in
The
the,
district court seemed to assume it.
well, there's a stamp on the bottom of the last page of the lease underneath the signature of the one party that the court tagged for that has a seal that you can't read anymore that says approved as the legal form and has a signature. So the court saw that as evidence there was at least one lawyer involved.
But whether or not that lawyer represented
Right,
both sides.
we don't know. We don't know. But I will say that West Virginia law is clear, and this is the BlackRock Capital case, that even 100% parent-subsidiary relationship does not make a per se procedural unconscionability if they have a contract between them. And what my colleague is essentially asking for here is a per se rule that when there's some overlapping ownership, there's procedural unconscionability and enough to get you over that hurdle and get to the second. Well, they actually argue about whether it's a 2-factor test or not, but they think that's enough, and I don't think this court should go there. Now let me talk about the 2015 consent, which you raised, Judge Floyd. I think the best textual argument on that one is that you have to give meaning to the idea of the 2015 control group. It was Mitch Potter and his entities. And yes, it was wiped out in the 2019 bankruptcy, definitely wiped out, 100% wiped out. So it can't ever be transferred away from them again. So it's over, and that's the only way to give meaning to that sentence. Otherwise, you could have just written it to say any transfer of 50.1% requires our consent, but that's not what it says. It says any transfer away from this particular group. And I think the district court, yes, everyone agrees that the bankruptcy didn't give them the right to consent, and the transfer happened, and it wiped out the group. But it wiped out the group nonetheless with an assignment, and it can't ever happen again. So I just think we have the right textual argument, and this kind of goes to harm. We didn't have a frivolous argument that we didn't need their consent. That's why, we had a declaratory judgment action about whether or not that clause was still effective to require a consent or not, and our argument was non-frivolous. It was in a declaratory judgment action. We didn't just willfully disregard it. We have a good argument that it's just not so. So I'll save the remainder of my time. Thank you.
Thank you very much, Mr. Glasser.
Your Honor, I can tell by the questioning that the court is having a difficult time with our forfeiture argument. I'd like to emphasize that in West Virginia, we have a whole line of cases that indicate that where there is indifference, frequent violations of a contract, where there's injustice, where there's fraud, where there's a whole litany of things that justify equity jurisprudence, and there's no adequate remedy at law, equity entitles an owner like Pocahontas Land to get a forfeiture. It's the only relief that is meaningful that we can get in this case. I would like to read what the West Virginia court says, partly in relation to the Bethlehem Steel case, which is what the district court limited its decision on forfeiture. Bethlehem Steel was limited to a finding that there was an adequate remedy at law. And here's what the West Virginia court says about that. The phrase adequate remedy at law is often misinterpreted. The controlling question is not, does the party have a remedy, but is the remedy fully commensurate with the necessities of the parties? The court goes on, to defeat equitable cognizance, the legal remedy must be full. It must be complete, it must be adequate. If it does not actually compel the performance of a duty, it cannot be said to be fully adequate. Again, the court says, to deny equity jurisprudence because of a remedy at law, the legal remedy must be as complete and efficacious as the equitable remedy. So in this case, the relief Pocahontas Land got was $1, nominal damages. Clearly, that was not as efficacious as the legal remedy. It did not compel performance of the obligations in this case. It simply does not meet the requirements of the West Virginia cases.
Well, before you run out, you have about to run out of time. I want to go back to one more question about procedural unconscionability. Are there any factors beyond the shared ownership in Loop Creek and Copper Cove that support a finding of procedural unconscionability? And I'm asking that question because if you can't get beyond that, I don't see how you can win.
We recognize, Your Honor, you are correct. West Virginia requires both procedural and substantive. We got a strenuous dissent that we ought to get away from that. But,
Sure.
but
I'm
the
not
law is,
arguing it's right. I'm just arguing
Yeah.
that that's the law.
we agree, Your Honor. We have to show some procedural unconscionability. We believe these facts demonstrate that the surrounding circumstances, when they entered into this contract, we can't prove that there was actual coercion. I mean, obviously, there's no witness left that can really tell us exactly what happened. All we can do is sit here today and look at a contract that is fundamentally unfair to us. We think it was unfair when it was entered. And so we look at these facts and think, well, what was the procedure? What happened? And we see, and we agree, 40% controlled by the Andrew Mellon interest, but they owned 100% of the common stock. They just had 40% of the voting control. But we submit that, and shareholder suits indicate all the time, you don't have to have a majority, you don't have to own it all. Sometimes the minority has a very strong influence in the outcome, and we think that when you combine this overlapping ownership and the circumstances with the fact that you had an unfair contract, to us, it leads to a conclusion, at least there was some slight procedural unconscionability here that would justify a finding of
Well,
an
you know,
unconscionable contract.
Is your argument also that the royalty rate in 1937 was unreasonable?
We cannot argue that. In 1937, you did see rates like that, but what you did not see was the combination of the ability to renew indefinitely into the future with no reopener. And the end result of that is clear. You don't have leases like that anymore. They just don't exist because they're fundamentally unfair. So, in conclusion, on the unconscionability, both parties did extensive research, but it is clear from all the evidence that there was the surrounding circumstances, in our opinion, at least indicate there was a genuine question of fact on the procedural aspects of how they entered into this contract.
Thank you very much.
Thank
Mr.
you.
Lane.
Thank you for having me back. I'll just address a couple things that just came up. The first is, there's no need to remand for more. My colleague just said we have no other evidence of what happened. There's no live witnesses. There's nothing new that could be found about procedural unconscionability at a trial on the matter. There's 40% of the voting stock held in the parent, but there's no other witness or evidence they could bring to talk about any other procedural unconscionability. I think we just heard that. And then the second thing we heard right at the beginning of the argument was about, willful indifference. And I think I addressed why it shouldn't be regarded that we've acted with willful indifference on the 2015 consent issue. At least that we had a good argument that it didn't continue to apply. We also met the requirement. You got to remember, at the bottom of the 2015 consent, it says consent cannot be withheld. So even if it did apply, it can't be withheld if the person coming in has reasonable coal mining experience and reasonable financial standing. And the court, in assessing damages, looked at that and said, and this is at pages 44 through 51 of its opinion, it's very clear. The court said, well, you kept the same employees for 4 years, 196 years of coal mining experience in the management at the coal mine, so they have reasonable experience, and you put up more than $100 million in the property and paid off the debt, so you have reasonable financial standing. So there's not a harm there. There's not a harm there, is what the court said. Even if there's a breach, there's not a harm. You're better off than you were before. And then on the deed of trust savings clause instrument, I think you got to this, Judge Floyd, in your discussion. These are the facts on that. Those are commonly used legal instruments. In the same counties we're talking about, we put before the district court that $7.7 billion worth of transactions away from us depends on them, and they covered like 1,200 leases. Our own savings clauses, in this case, covered more than 1,000 leases. And so they noticed default, that we didn't get their consent, taking the odd position. Normally a lessor would say, okay, the savings clause works. It doesn't put a lien on my property. But they take the opposite position, that it puts a lien on their property. We promptly sued for a declaratory judgment that we didn't breach. So we weren't ignoring the problem. We promptly went to court to get it resolved. And it was a case of first impression in West Virginia. And when the court ruled against us within 12 days, all the lenders, all the trustees under these complicated bond indentures got their act together, went down and filed a confirmatory supplement that disclaimed any right in this lease. So, so the court said on those pages 44 to 51, what articulable harm came from this? They can't point to any transaction they tried to do that got interfered with. Nobody may have ever even noticed, except for the court that we were in front of, having this argument. And a declaratory judgment's the right way to deal with these issues. So we weren't just ignoring them or not caring about their rights. We went to court to resolve two close issues of, interpretation. So that's my view of that.
All right, thank you very much.
Thank you.
I want to thank both counsel for their excellent arguments this morning. Out of respect and as an accommodation for my colleague, Judge Floyd, we'd like all the lawyers at the council table to come up so that we can greet you, and then we'll move on to our second case. Our second case is 25-1012, Retail Energy versus Advancement League versus Brown. Mr. Johnson, whenever you're ready.
Thank you, Your Honor. May it please the court. Tom Johnson appearing for the Retail Energy Advancement League and Green Mountain Energy Company. The state of Maryland has enacted a law that prohibits my clients from making any claims about the environmental benefits of their products, including by calling them green, clean, renewable, environmentally friendly, and, quote, similar claims, among others. My clients accurately use these terms to describe the renewable energy certificates, or RECs, that they sell to consumers. And the Federal Trade Commission has blessed RECs as the way that companies substantiate renewable energy claims. In Senate Bill 1, however, Maryland prohibits companies from marketing RECs consistent with federal law unless they are Maryland's preferred RECs. That is, unless they are RECs that further, quote, Maryland's interest in promoting the development of regional renewable energy sources.
Is that in the statute? Is that the purpose of this statute?
Your Honor, they are telling you in their brief that that is one of the substantial state interests. In fact, it's the only substantial state interest that they argue in their brief supports the particular limitation in the statute, which is that you can only market RECs if they come from the 13-state region known as the PJM.
No, go ahead. Go ahead.
And the reason that they give for that, Your Honor, is because they believe that those RECs have environmental benefits for Marylanders. They argue that there are benefits to having RECs that are local, as they're characterizing local, even though it's this far-flung geographic area. And the point, Your Honor, is whatever interest Maryland might have in deciding what its renewable portfolio standard is, we're not arguing that they may not have legitimate ways of furthering those interests. What they can't do is restrict speech.
I thought your first well, sorry to interrupt you there, but I thought your first argument was that that wasn't the interest that was presented to the district court below.
That's correct, Your Honor. I mean, I think that they've also waived it, and I think the court could consider that waived.
Well, the reason
But-
I'm asking, and maybe, I think you're about to make this point, is it would seem to me that that would be a legitimate interest that any state would want to promote, that is the health and environment of their, of the state and the health of their citizens, but you say they can't do it in this way, even if they had preserved the argument?
That's correct, Your Honor. So I think this is like how what the Supreme Court said in Sorrell. So let's assume for the moment, Your Honor, that we're talking about this under intermediate scrutiny. I mean, we have arguments that strict scrutiny should apply. But whether you have a substantial state interest is only the first prong of that analysis. So certainly caring about the health and welfare of your citizens, I mean, that can be a substantial state interest. But then the question is, what means do you use to advance that interest? And so, for example, in Sorrell, Your Honor, the Supreme Court said that what you cannot do, absent evidence of consumer deception, and again, there's a separate consumer deception argument in this case, but with respect to this particular mix of RECs, what the state is telling you is that they want to promote their green energy claims, their environmental goals, by preventing my clients from talking about different types of benefits of their products. And what the Supreme Court in Sorrell is saying is that you can't limit speech as a means of promoting your interest in what you think is the good of your citizens. There may be other ways that you can do that, but you can't limit speech on an important question of public debate.
Well, that issue of promoting regional renewable energy, even if they waived that second state interest argument, we're here on a preliminary injunction. Can't they raise that before the district court after we decide the preliminary injunction?
They may be able to, Your Honor, but I mean, for
Well,
purposes of this relief.
Assume they can. Wouldn't that make it more, that make it more likely that they might proceed, they might prevail on the merits?
I don't think that interest helps them, Your Honor, because again, the question is, have they chosen a means here that is permissible to advance that substantial state interest? And what they have done, Your Honor, here is they have prevented my clients from marketing the renewable benefits of their products. So my clients cannot currently say that the RECs that they have been marketing and selling to consumers in Maryland are green because they're backed by wind or solar power, that they're green because of their emissions profile, because they reduce carbon dioxide emissions, and because that helps to offset climate change, because it reduces particulate matter in the air. These are all things that are true. They're true, accurate claims. That's why the FTC has said.
So let me make sure I understand what's going on here. So you're saying that your clients are still able to sell energy in the state, but they are not able to represent what that energy means?
Yes, so I would clarify that in this way, Your Honor. There's two markets that are created by this statute. So one is the green power market, and in order to enter the green power market, you have to comply with these speech restrictions, right? So the prohibition on speech, there's also a disclosure requirement in the statute. And then you need to go through an administrative process to get the price of your green power product approved by the commission. Now, if you don't want to go through that process, Your Honor, you can participate in the regular power market. But in the regular power market, you're price capped, and the only thing that my clients would have to distinguish their products in that market from the incumbent utilities product is speech. It's to advertise to eco-conscious and eco-friendly customers that you ought to switch to our products because they're more environmentally friendly.
Well,
This statute prohibits them from doing that.
And just at a basic level, before SB 1 was enacted, your companies were calling the product clean and green, even though you were supplying non-renewable energy into the grid. How is that not misleading?
So, Your Honor, I don't think it's the case, at least with respect to my clients, that they were doing that. My clients sell 100% renewable products. The only difference here between these products and the ones that Maryland is permitting people to market is that some of the wind and solar power is sourced outside of Maryland's preferred region. And our clients say that there's benefits to that consumers like, the ability to offset global climate change, which doesn't know, there's one atmosphere. It's not a distinction between, Maryland or Texas or North Dakota in that regard.
Even though that is
And-
what your clients are selling, what ultimately reaches the consumer? Because I think that was the source of what is misleading.
Yeah, so that's critical, Your Honor, right? So if we look at the consumer deception rationale, what the evidence shows in the argument that they're bringing to this court is they have a couple of anecdotes from consumers who are
Well,
saying,
it was more than a couple.
well, there was two affidavits from consumers, Your Honor, and then they had a report from a nonprofit coalition, but that did not have any additional consumer anecdotes in them. So the two affidavits that I'm familiar with, Your Honor, and the ones that they are citing in their brief, these consumers are saying, we thought that what it meant to purchase renewable energy is that our house was physically connected to a wind farm, right? That we thought we were getting energy directly from a renewable resource. The problem is if that was the problem, Your Honor, then perhaps additional tailored disclosures about RECs might be appropriate to alleviate that confusion. That might be a more tailored response to that. But what they did instead, Your Honor, was to create a line where they're still permitting the marketing of RECs. The Maryland portfolio standard that they are trumpeting, that is still based on unbundled RECs. It's still power that is not going directly to a consumer's home from a renewable resource. And yet they're here telling you that these terms, green, clean, renewable, et cetera, are inherently misleading because consumers inherently believe that what that means is you're connected to wind power.
Could the state just simply bar your clients entirely from engaging in the market in order to promote their local interests?
If that happened, Your Honor, we wouldn't have a First Amendment argument for sure. I mean, we might have other arguments. There's a Dormant Commerce Clause claim preserved in the district court. But it's the same in Sorrel, Your Honor. The state there, Vermont, was going after prescriber practices that it believed were detrimental to patients. And perhaps they could have prescribed some of those prescriber practices. Simply because the state might be able permissibly to limit entry into a market or to prohibit you from entry into a market doesn't mean that they can restrict speech. That's the whole point of this multi-pronged test, Your Honor, right, under Central Hudson. Just because you have a substantial state interest doesn't then mean you can restrict, truthful, accurate information about products.
Can I ask you about the Second Circuit's decision in Alco? Is that, I know it's not dispositive in any event, but does that resolve the case adversely to your client?
Sorry, Your Honor, could you remind me of the
Alco
holding
case,
there?
The second, well, it was a Dormant Commerce Clause argument and involving Connecticut and northeastern states, which seemed to align pretty well to the facts of this case. And the court there found no problem with the regulatory restrictions that were imposed in that case. And they might not have been speech-related. I'm trying to remember if they were, but you tell me.
That's right, Your Honor. So, again, I don't think that's before the court, because that was a Dormant Commerce Clause argument. We're here obviously on a preliminary injunction with, on a First Amendment argument. I do think that mere protectionism is not a legitimate state interest, and so I do think we can draw that kind of I mean, we would disagree with that decision. I mean, there's a Sixth Circuit decision involving utilities and RECs that came out the underway, found a Dormant Commerce Clause violation. But again, I don't think that's really important for purposes of this discussion. Because again, Your Honor, I mean, I can concede.
Didn't you raise it in your reply brief? The Dormant Commerce Clause?
No, Your Honor, we would not have done that. If we mentioned it, we might have, but I don't recall. But that's not. We had two claims before the district court: Dormant Commerce and First Amendment. Our preliminary injunction motion is solely on a First Amendment argument. If we raise it, Your Honor, it might have been to note you have a 7-state amicus brief in front of you, and they make the point that at some level protectionism, mere protectionism, is not sufficient for a substantial government interest.
Well,
but let's assume you don't.
I might be off the wall about this. I mean, this is all kind of a fiction anyway. I mean, you can't put clean energy into a grid at point A and get that same energy at point B. I mean, the grid takes all the energy that comes in it. So what it is a feel-good thing. If you get more than 51% is clean energy, everybody feels good about it. And that's a fiction. But on the other hand, why shouldn't the state of Maryland be able to require you and other utilities, if you, to meet that requirement about clean and green energy, to satisfy that fiction, to make the consumers feel good, like recycling. We don't know where recycling goes, but everybody feels good about it. You pick it up, they say, to a recycling place. So why isn't this a legitimate goal of the state of Maryland?
Sure. So, I mean, a couple responses to that, Judge Flay. Actually, I think this goes to your question too, Judge Giles, about how the grid works, right? So, Your Honor, absolutely, they might have legitimate means to help, make people feel good about their purchases, to advance their interests. But again, what they have done here, I mean, you're absolutely right. The way that the grid works, it's impossible to know whether the energy from a particular renewable resource is reaching somebody's home, right? And so what they have done is they have taken a 12-plus state unit in which they are currently permitting people to market their products as green if they're starting from renewable resources as far away as Chicago, but you can't market your products as green if you're drawing from resources in New York, Connecticut, parts of Virginia, places that are much closer to Maryland. And even if you had a renewable resource down the street, it's not a given that that energy is going to reach your house, just based on the physics of how electricity works. And my point, Your Honor, is not, again, that I need to persuade you about kind of the court needs to kind of grapple with the physics of the grid. The point is that the means they have chosen here is to cut off marketing. It prevents my clients from making claims about why they believe that their renewable resources are better for consumers.
So can I ask you, so with respect to that, could the state of Maryland have said, instead of the limitations that they've imposed here with respect to speech, have indicated, well, the statute is going to require those favored states, the ones that you identified within that grid, to be preferred by the state of Maryland. And your clients can market your products as green, but they also have to say that they don't fall within the preferred region that the state has demarcated as their, the ones that they have, that they've identified. Would that be okay?
I think if the statute did not muzzle us in that way, Your Honor, but simply included a factual disclaimer along the lines of, and this already happens with respect to what was the pre-existing renewable portfolio standard. You need to make accurate disclosures about the source of your RECs, and then you can market the products however you like. I don't think we would be standing here. But that's not what they did, and that's precisely the tailoring analysis that is required, whether you're talking about strict scrutiny or central Hudson. Here, they cut off speech about every word that could relate to making an environmental claim about your product. So it's not, it's neither tailored to the evidence that it doesn't directly advance their interest because they're already permitting a lot of other speech about RECs, and it's not tailored precisely because they didn't consider the alternative you just suggested, Judge Diaz, which would have been factual disclosure.
I have one final question, and then my colleagues might have some others. So this case proceeded at the district court, I think, on a contention, on a facial challenge, as I understand it. And now you're making it what appears to be an as-applied challenge on appeal. What are we to make of that? Does it matter?
Your Honor, I don't think it matters. So first of all, I mean, the Supreme Court has said that with respect to the facial challenge, where the challenge is categorical, where it applies the same in all cases, then there's really no need to consider whether it's facial or as applied. I mean, so here, Your Honor, anyone who is similarly situated to my clients who are selling out of region RECs, who want to make green marketing claims with respect to those RECs, they are categorically prohibited from doing so. So the statute, I don't need to show every application, right? On a First Amendment facial challenge, it's just substantial number of applications, or it's, in relation to the sweep of the statute. Now, we have demonstrated with respect to our clients that the statute's unconstitutional. We put declarations in the record. We have established, obviously, their standing. We've established that as applied to them, the statute is unconstitutional because it applies to their products. They've cut off their marketing. They've, in many cases, exited the market. So I think that the court could, the point with raising that in the brief, Your Honor, it's the court's discretion, I think, to fashion the remedy. It could limit the remedy to our clients, but we do think that we've established a facial challenge.
And what would be the remedy in your mind?
Well, on.
And I lied, I had another question.
Yeah, no, that's fine, Your Honor. In this posture, it would be to reverse and to grant the preliminary injunction and allow proceedings to continue in the district court.
Do you have any? Thank you very much. Mr. Handley.
Morning, Your Honor.
Morning.
Good morning, may it please the court. Appellants are asking this court for an extraordinary relief of a preliminary injunction to allow them to continue to mislead Maryland consumers about the energy products that they and other third-party retail sellers provide. Prior to the adoption of SB 1, retail energy suppliers operated a dysfunctional market in Maryland, advertising their products as 100% wind, 100% solar, 100% emission-free, and otherwise green and clean energy, with no standards by which consumers could measure these alleged green offers. In that time, Maryland consumers paid significantly higher rates for that energy. Despite this, many Maryland consumers would later discover the actual energy they received was no different than had they stayed with their standard utility. Instead, the only difference for consumers paying the significant higher rates were the inclusion of out-of-state renewable energy credits, or RECs, offered by retail energy suppliers that were paired with otherwise non-distinguishable standard energy. Now enacted, SB 1 prevents appellants and similar retailers from using confusing and amorphous buzzwords such as green or clean to trick consumers into believing they're receiving renewable energy from the grid.
So why it sounds like certain producers of energy are prohibited from using those terms while others are. And on what basis is the state of Maryland making that distinction?
Your Honor, the retail energy suppliers who are utilizing these claims that they are 100% green, 100% clean, and utilizing out-of-state RECs are unable to market in that specific terminology unless they meet the new green energy definition as laid out in SB 1.
And the definition is what?
The definition?
It's a geographic definition, right?
It is, Your Honor.
So how does that ameliorate confusion? They say their energy is every bit as green as the energy being produced by those producers in that region. Do you have any reason to dispute that?
Your Honor, I'd say two things. First, RECs in Maryland are not RECs in Texas, are not RECs in California. RECs are state property law. This is the Alco case, mentions this as well. And so a REC is not a one-for-one across the country, a one-for-one swap. So Maryland currently has no ability to determine, what, if any, what the renewable energy credit, what renewable energy is tied to that renewable energy credit in a different state. Versus in Maryland and in the PJM, they would have a better understanding of that. Maryland specifically obviously sets its own standards about what is renewable under the RPS, which were mentioned before. And it's...
What about the others in the region? Can you tell with respect to those?
I don't know, Your Honor. However,
Wasn't that undermined in the claim in terms of what is green energy then?
well, it's a combination of things, Your Honor. It's the misleading nature of these claims at the forefront is the fact that salespeople would go to people's homes. This is all just retail, residential energy. They'd go to people's homes. They would say, do you want to buy 100% non-emission energy? And this is the catalyst behind getting them to sign up for this. What's not, if the company simply said, we are going to be providing wind energy RECs from Texas, SB1 doesn't stop that from happening. They could still market their products truthfully under SB1 by saying, we can provide you with 100% renewable energy credits based on wind power.
But that's not what the statute does. I mean, it doesn't say you can only market green energy if you tell the consumer that it comes from state X. It says you can't market your product as green energy, period, because it comes from state X, even if it satisfies the requirements of the green energy definition that the state itself imposes.
That's correct, Your Honor, that it does specifically mention, specific words in amorphous terms that now have a definition. They're either required to meet 51% of the renewable energy output or RECs in the PJM, or 1% above the RPS standards. And I think the ALCO case is a really important one to sort of demonstrate both the complexity of RECs to the consumer in the first place, but also to emphasize the fact that this regional dimension, the fact that a REC out in Texas, or I'm sorry, out in Chicago may be part of the PJM, that's entirely the federal government's purview to create this regional grid setup. Maryland has nothing to do with that in terms of, determining. That was FERC, as we put in our brief, that set this region up in the first place. So that there's this potential outlier of wind all the way in Chicago doesn't.
I agree that the concept of RECs is confusing. I even struggled with it myself as I was reading it. But how does this law address that confusion?
Yes, Your Honor. I think it addresses it in two ways. It's the combination of the green power definition, which will give consumers the understanding that at least 50% of the energy that they received are local RECs in the PJM, but that's also tied with the disclosures that are now a part of SB1. This is where the RECs were sourced, from what energy they were sourced by, and what state they came from. All this in its totality, gives these consumers a much better picture of what product they're buying, what product they're going to pay more for in the green power marketplace. And before, it was frankly the Wild West with some of these dysfunctional pieces. And SB1 obviously is, there are many different consumer protection pieces to this. We're obviously talking just about the green power definition and this disclosure requirement, but the ending of variable rate contracts, the requirement for salespeople to be registered, and the end of commission-based sales. So there's more here than just the green power definition and the disclosures.
So can you address this question of exactly what argument was made to the district court below? You seem to have switched horses on appeal and moved toward an argument, or maybe you're making both, that part of the purpose of this statute is, in addition to remedying consumer deception concerns, that there's also a purpose of promoting green energy for the benefit of Marylanders in the local area. And to me, that sounds entirely legitimate, but it didn't sound like, that didn't seem to be the argument that you made to the district court. Do I have that right?
I think mostly right, Your Honor, in that we are making both these arguments because I think it's important to recognize that the state of Maryland, since at least 2004, has had this substantial interest of trying to increase renewable energy creation in the state of Maryland itself. We did mention this at oral argument during the motion for the preliminary injunction. So I do believe it was preserved below. We did mention both the importance of RPS standards to the state in general, and also this idea that this bill assists in promoting green energy options here in Maryland and the PJM, and similar health benefits if renewable energy resources were increased as a percentage versus more dirty energy resources.
Well, assuming that's preserved, and that's an open question, but why isn't the better fit, and maybe that's not required, but why isn't the better fit as a matter of statute to say explicitly that anybody who is interested in marketing green energy in our state has to disclose whether or not that energy is coming from the region that's been identified by Maryland is consistent with with promoting its environmental and other social goals, or not. And if you're not within that preferred region, you have to say so, but you still get to market your energy as being green if you can accurately represent that to be true. Why isn't that the better fit here?
I think that's not the better fit, Your Honor, because RECs, again, in Maryland versus, say, Texas or Oklahoma or elsewhere are not necessarily a one-for-one equivalent. RECs are a creation of state property law. What a state determines is renewable versus a different state are different. So I think it's important that Maryland makes this distinction, and at the forefront, this is an attempt to stop misleading claims that were causing individuals to sign up for these offers based on the mistaken idea that they were going to get actual wind energy. And I think, as pointed out before, this was the General Assembly heard.
Yeah, but aren't you, on the other hand, compelling an outside energy producer to make a statement that's literally not true, that even though they might well be producing 100% renewable energy of some kind, whether it be wind, turbine, water, whatever, that they're now being compelled to say that it's not?
No, Your Honor, I don't think that's right, because these energy providers are not creating the energy. They are purchasing the energy to then go into the Maryland grid. And so what they're doing is a Texas REC has no way to get to Maryland in the PJM, whereas RECs created the renewable energy that is paired with the RECs in the PJM are actually part of the Maryland grid and would provide actual renewable energy to the Maryland and PJM region in a way that if these companies are simply buying RECs out in Texas, they're not actually producing green energy. They're
That
just simply,
reaches Maryland.
exactly, Your Honor. They're simply providing the RECs, which concededly are the way in which you are able to do an accounting. As mentioned before, when you turn on a light, you don't have some indication.
The grids aren't interconnected?
Not to the extent that some renewable energy all the way in Texas is going to
Let
get to
me
that.
go back to my fiction. I mean, you talk about signing up customers door to door. That can't possibly be true, because these energy companies have areas of service, and so but my point is this whole thing is to create a feel-good thing, because energy cannot be separated out. It's all in the grid. It's mixed in, however how it was generated. But what you're doing is you're allowing companies to advertise that they provide green energy if they meet certain requirements, and essentially the consumers, while they don't really know this, all they know is that this company, at least 51% of its energy meets that requirement. and it's put in the grid, and they can advertise it that way. That's the way it works, right?
Yes, Your Honor, that is the way it works. I will push back just briefly on door-to-door sales. That is what was happening here.
Well, how can that be? Because, I mean, the power lines, I mean, as I understand it, you've got a service area, say Duke Power, for example, here, or whatever it is, Dominion here. They have power lines everywhere, and some other little company's not gonna be able to step in and say, this is my power. I mean.
So, Your Honor.
Yeah, go ahead.
Thank you, Your Honor. The best explanation of this is the district court's opinion, which cites to an opinion that explains in Maryland in 1999, I believe, Maryland basically opened up its energy grid to allow individual residents to purchase their energy from third-party energy providers. They would still use the distribution network, which you're discussing here, of Dominion or BGE like we have up near Baltimore, but the actual purchasing of the energy itself would be through this other entity.
It's free choice there.
Yes, Your Honor, that is how it was framed.
Oh, say that again.
It was a free choice. I believe the bill that went through the General Assembly at the turn of the century was some sort of free choice act that opened up the state's energy market. And this permitted sales to third-party entities outside of your normal utilities.
Well, I understand what you're trying to do in terms of if a company provides at least 51% of their energy is clean, green, whatever, then they can advertise that way. I get that, but what I don't get is this door-to-door thing.
So one thing that may be helpful, Your Honor, we identified several pieces of testimony that went before the General Assembly, including, advocates for this bill and consumer protection advocates, the People's Council, which in Maryland advocates for Maryland consumers. And they all recognized that there was a certain amount of dysfunction in this space, in that individual residents were having their doors knocked on, that there were some actors within the space that were focusing on low-income neighborhoods. There were even stories of people being signed up for this without their knowledge, individuals basically on their deathbed being signed up for it, and then their families finding out later that they've been signed up for this.
So is it this simple? Say we got a street, and you got three power companies, X, Y, and Z. So X goes to one house and people sign up for X energy. Y goes to the next house, they sign up for, that's who they pay their bill to. Is that the way it works?
So everything would still come through your normal utility, but you would be paying these additional monthly payments as an eco buyer, or maybe you've just been sort of confused and just gone with it. But yes, you'd be paying these third party, these retail energy suppliers that are third party instead of your standard utility.
But aren't there plenty of consumer protection statutes that are supposed to deal with those issues?
There are consumer protection statutes, Your Honor. However, this, I think, is a very specific.
And how does this statute stop those examples that you just described?
Yeah, I think it stops those examples in sort of the two ways in which I discussed before. I mean, so Maryland believes this is an inherently misleading attempt to get individuals to purchase green energy that is frankly not green. But by having this definition so that residents and consumers can make informed decisions about the energy that they're going to purchase, and the disclosures that are going to tell them.
So are providers no longer doing these door-to-door activities?
So I think it's important to note, as we did in the brief, that this is a facial challenge, and this isn't about individual as applied. But it's my understanding that due to SB1, that none of these third-party energy suppliers that make these alleged green offers are operating in Maryland currently. as a result.
Now, one thing that they raise is that they can't even use, based on this law, green in their name. Is that true?
No, Your Honor, it's not. And I think that in numerous places, appellants attempt to sort of say that this is about their core political speech related to green as an idea or climate change, et cetera. The district court, I think, rightfully saw through that and said that, that's not what's going on here. This is specifically targeted to commercial speech. And as an example that they give in their brief, they have this 2024 voting guide. When you go onto that website, as you scroll down, at a certain point, you get a pop-up that is unable to be moved from unless you X out of it, and it says some version of, sign up for our sensational offerings. So this is all window dressing to commercial speech and all window dressing to advertisements to try to get individuals signed up to purchase this energy, Your Honor.
Do you have anything else?
Just in conclusion, Your Honors, this is a facial challenge. This is an extraordinary remedy that's being sought here, and the district court was correct in denying that motion. Thank you.
All right. Thank you very much.
Thanks. So a few points on rebuttal, Your Honor. I mean, I've heard from the bench today, and I think it's something that we would not dispute. There are substantial state interests that the state has here that it could adopt permissible means to advance, and those interests could include consumer deception, health and welfare of their citizens. We're not disputing that, Your Honor. But if you look at Central Hudson itself, which set up this framework for commercial speech, you can't restrict speech unless the means in which you do it directly advances those interests and is appropriately tailored. So Central Hudson itself, Judge Diaz, this deals with utilities, heavily regulated industry. There was an argument that the utilities promotional materials were outside the scope of the First Amendment. The court said no. The state advanced a conservation interest. Similar here, not the same exact thing, but it said, we don't want promotion about accurate utility prices because we're worried that's going to lead to people using too much energy, off-peak usage and the right. We've got an interest in conservation. The Supreme Court said that sweeps too broadly. You are sweeping in a lot of lawful speech. And then on tailoring, the court said that the state had erred in not considering more tailored options, such as, for example, requiring the advertisements include information about the relative efficiency and expense of the offered service. That's exactly what you've suggested a couple of times here, Chief Judge Diaz, that they could have, if they really cared about regionalism, if they had an interest in the PJM, they could have tailored factual disclosures, which they already have with respect to their renewable portfolio standard, rather than cut off all debate about what it means to be green energy. It's the same situation here. And Judge Floyd, I'd like to address, a couple of times you've talked about what is this all about, right? It's about the consumers feeling good, for example. It's also about subsidizing green power, right? What these recs have done is created this secondary market where consumers are pairing each kilowatt hour of regular energy with a kilowatt hour of clean energy. So that is subsidizing the wind farms, it's subsidizing the solar farms. And the reason that matters, Your Honors, is consumer, an eco-conscious consumer could say, I don't care where these farms are located. I'm just kind of interested in the environmental attributes of this power. In fact, in some other states, it's favorable jurisdictions where it's cheaper to build these farms, and so it's got more of an impact on the atmosphere than in some of the states in this area. And the way that the state has drawn this line, if you have 51% RECs within the state, within the PJM region, and 49% coal power, you can still call that green. But if you have 100% wind and solar from outside of the PJM region, right, would have to comply with the RJM standards. So let's say 35% local, 65% outside, and it's all wind and solar backed, you can't call that green. So again, it's a fit problem. There might have been more narrowly tailored ways for them to do this, but this was not one of them.
I want you to address your severability argument to a certain extent, because what if we did find that it went too far in terms of the marketing piece, but what about the disclosure piece? Can they both still, why couldn't that proceed?
I think the problem here, Your Honor, is that everything is keyed off the definition of green power. And so in order to participate in the green power market, I mean, this is how they wrote the statute. They wrote the statute in an impermissible way. To market green power, you need to comply with the speech prohibitions we've been talking about. You need to comply with the disclosure requirement, which uses some of the same terms like renewable that are part of the green power definition. And you need to get your price approved. So to cut out one or more of these, really, to my mind, would require this court in engaging in a rewriting of the statute where it wouldn't all hang together. And then participation in the regular power market is defined as power other than green power. So that is why, if you look at the state's brief, Your Honor, they are not contesting that this dual market structure is all integrated. They're arguing that there are other things, such as the ban on variable rate contracts, the licensing requirements, that are outside the purview of this dual rate structure. So, Your Honor, I will say, I mean, our position is the whole statute should be enjoined, but I think, at minimum, these dual market provisions all hang together in the manner that I was describing.
If the green, related to Judge Giles' question, if the green energy provisions did not exist and this was simply an issue of disclosures, would you be here today?
Well, I think, as I said before, Your Honor, if it's purely factual disclosures, and particularly what you're saying, which is that, we had to disclose, are our recs sourced in PJM? Are they not sourced in PJM? Then no, we would not be standing here, Your Honor.
Do you have anything else? All right, thank you very much.
Thank you.
Our thanks to both counsel for their excellent arguments this morning. We'll ask you to come up and greet us and adjourn court for the day.